Bells shall swing out in the barroom night. Enter Patty Valentine from the floor above. She sees a bartender in a pool of blood. Cries out, they kill my love. Here comes the story of the hurricane. The man the authorities came to blame for something that he never done. Put in a prison cell, but one time he could have been the champion of the world.
Everything is quiet for a few months at this point. Welcome back to Corrupt Clearfield, and as a reminder, especially with this episode, since we're actually going to look at more documents just in this one than all the other episodes combined, to check out the Dropbox folder at corruptclearfield.com, where you'll have access to all the legal documents so you can read along as well. Make sure there's no BSing going on, and really just verify the record so that you know that none of this is coming from me. It's simply the product of taking all the existing information and piecing it together into one coherent, comprehensive narrative. As I mentioned, everything was quiet for some time. It's not until April, when jury selection is right on the horizon, that things start to pick up. Now, just as a little bit of a reminder, there were two separate situations John was dealing with back at the end of August / beginning of September in 2015. There was the PFA violation, which came via the alleged Facebook like. That was taken care of at the end of October with that hearing. Pled guilty, everything is done there. But we had the two charges for stalking and harassment. One, of course, a misdemeanor, one a summary violation, and that constituted a jury trial. There were numerous continuances up until this point, but we finally in April reached the point where we were ready to go to trial. And when I say we, of course, I say John, our family. Then the bombshell drops. On the day of jury selection, Stephanie Cooper filed a motion to withdraw as counsel. Now, this may seem at first to be out of the blue and completely unexpected, but after I read the transcript from the hearing for the motion to withdraw, I'm going to go over some information with all of you that will put this into focus and help blend it into the narrative so it actually makes sense contextually speaking, and I think sheds a lot of light on exactly how John never had a fighting chance to begin with. Now, I'm going to read the transcript verbatim as best I can, and I apologize if some of you are not auditory learners. My wife is actually one of those people. If that's you, you may want to fast forward through until the end of this reading because it might just sound like convoluted drivel, and just read the transcript for yourself via the Dropbox folder. This is document number 9. For those of you who do enjoy listening or just happen to be out and about and don't really have the time to read the transcript for yourself, you can always do that later, but for now, we will go through it together. Starts off with Mr. Maines being the attorney for the Commonwealth. He says, "We are here this morning on a motion to withdraw as counsel. Miss Cooper," that's Stephanie Cooper, John's attorney at this point, not for much longer though, of course. She says, "Thank you very much. I filed the motion to withdraw my appearance on behalf of Mr. Gill. He came to see me and we talked about making some payments. He made payments of $1,500 and hasn't made a payment in maybe 4 months. I advised him there would be an additional fee for the jury trial of $7,500, and he advised me he could make arrangements. But he has not advised me what those arrangements would be. I would be reluctant to not receive the vast majority of that sum prior to going to jury trial, because in my experience, once you are done with trial, people tend to be done with paying. In addition, just in our conversations this morning, have sort of reached an impasse in terms of being able to work together towards his representation. The court says, Mr. Maines, Commonwealth's position as to this motion. Mr. Maines says, the Commonwealth does not oppose the motion. We would ask the court to exercise your sound discretion. The court says, sir, would you raise your right hand? Defendant was sworn, it says in parentheses, that being John. The court says, please state your name for the record. John Gill Sr. Sir, you are the defendant in this matter. Yes. Do you understand what is going on here this morning concerning the motion to withdraw as counsel filed by Miss Cooper? Yes, I do, sir. What is your position concerning that? John says, I actually paid her $2,100 and she was supposed to represent me. She had information that I had 13 witnesses beforehand and that I was not there in the white car stalking Tara at all. I want to know what your position is concerning your counsel withdrawing from further representation. I'm against it right now, sir. The reason for that is because I can work with her and she can work with me, but I don't know what else to say. Let me ask you this. What Miss Cooper said about payments not received in the last 3 to 4 months, is that correct? That is correct, sir. Do you expect her to work for no compensation? No, sir. What do you mean you want to work with her? What do you mean by that? She had documentation that I was not guilty of these charges messages, and she didn't do anything about it. She told me, and at this point the court cuts John off. All I'm talking about is she said that there was a retainer that was sought, and you failed to pay that. That correct. I wasn't able to pay it, but I told her we could make arrangements. Your trial is scheduled for June 1st, which would give you a month and a half to obtain counsel. I'm going to grant the motion to withdraw as counsel by Miss Cooper. And Mr. Gill, you have the opportunity to obtain other counsel, but we will proceed with jury selection today, and I will have the public defenders sit with you in an advisory capacity this morning for jury selection. And that is the end of the transcript for the motion to withdraw as counsel. First of all, John kept a detailed log of Stephanie Cooper's failures to get back to him. In fact, even if Stephanie Cooper's claim that he had only paid her $1,500 and that she had told him he would need $7,500 more for a jury trial were correct, what had she done with the $1,500? Because as of this point, she had filed nothing on John's behalf. She had not actually fought as an advocate on his behalf despite his continued assertions of innocence, and moreover, she routinely railroaded him at every PFA violation hearing when the PFA had actually gone into effect in the first place, and at every opportunity they had to speak in between. She basically told him, this is what we're doing, you need to sign here so you don't go to jail. It's what she did when the PFA was issued. That's what she did when she was at the PFA violation hearing, which, let me remind you, there was no evidence present. There was no picture, according to Officer Podlisky, that had been taken that was present for Stephanie Cooper to see, yet she still presumed the guilt of John despite his continued assertions that he was innocent, and she did not advocate for him, instead saying, you are guilty, sign this or you are going to jail. What was John to do at that point when his own lawyer had failed to advocate on his behalf? Now, if you'll check out the document that is in the Corrupt Clearfield file on Dropbox, again, you can access that at corruptclearfield.com, you will see that there's an example email of a time that John had emailed her, as he had done many times. And if anybody's interested actually in seeing further communications from them, I didn't want to inundate all of you with documents that weren't exactly relevant, that would kind of clog up the case file, but I have plenty of examples of him sending her messages, sending her requests, telling her that he is innocent and that he wishes for her to advocate on his behalf, and those falling on deaf ears. In fact, one of the documents you will see if you look in the Corrupt Clearfield file is you will see a timeline that John kept track of, showing all the times he had attempted to contact her and all the times she had not gotten back to him. In fact, if you look at the document, you will see that he was more than diligent in trying to plead his case and explain to her exactly why she should be advocating on his behalf, and yet we continue to arrive at situations where she is simply saying, sign this or you're going to jail, and John doesn't want to go to jail at that point, so any reasonable person feeling they have no other options would sign the document. And now, here she is claiming that though he has paid her $1,500, which, as I'll show in a minute, is false, she's saying, well, he hasn't paid me more money, so I no longer represent him. Stephanie, please, this is a challenge to you. Show me what it is other than showing up at a few select hearings and telling John to sign a paper or else he was going to prison you actually did to earn that $1,500. I'm genuinely curious because I can't seem to find anything anywhere that supports you did an ounce of work on John's behalf. Now, one of the more specific instances that John had requested Stephanie enter something into evidence that she did not was his list of alibis. If you remember earlier in the previous episode where I was explaining how Tara Gill had claimed that John had driven a car down the alley behind her house and that she had heard his voice but not seen him on a particular day, and how that day would actually come back to bite her in the ass. Well, the reason is that particular day, John had a plethora of alibis due to attending an event with many friends and family members over an hour away from that location. So he had a list of alibis that were all willing to take the stand and verify that he was not in fact at her house, driving on the alleyway behind her house that day, and he gave Stephanie Cooper this list well before this jury selection hearing. Stephanie never filed that list of alibis. You can view that document as well. Now, as to the payments, this is where things begin to get extremely interesting. Stephanie noted that John had only paid her $1,500, and it had been, I think, 4 months is what she said. I don't have the transcript again right in front of me, but it had been a while since she had been paid. While it is true that it had been some time since she had paid, that's only because John had actually paid ahead on a few occasions. He was giving her $300 a month, and he had paid $300 multiple times in a few months, so that he was actually paid up through January. He stopped paying in February, March, and April because Stephanie had not been doing anything for him, and he was trying to get in contact with her, and she would not get back in touch with him, as the record shows that is available in the file for you to all view. Now, what is most concerning, though, is the fact that I, via John's power of attorney, have obtained copies of all of the checks that he wrote to Stephanie Cooper with confirmation that they had been cleared through his account. And of course, after removing address and check number and bank information, I have included these in the file for all of you to view. You can actually take a peek and see that he has paid her $2,175 to date. That'd be $675 more than she asserted he had paid her in the motion to withdraw counsel hearing. And still, with this amount of money being paid to her, I cannot seem to find anything she did on his behalf other than show up, tell him to sign a document or he was going to jail, and then leave. She didn't get back with him. She didn't file any of the documents for the jury trial he asked her to file. But the question then becomes again, Stephanie, why did you say that John had paid you only $1,500? Why did you say that he hadn't paid in a few months, misleading the judge, when in fact you should have said he has only paid up through the month of January and he was trying to contact me, but I didn't get in touch with him, so he wasn't paying me again until we had a chance to speak. Very misleading as far as I can tell, and I would love an explanation from Stephanie Cooper. As you'll hear in a later episode, I tried to talk to her and ask her these questions myself, but she was evasive at best. Now, there are a few more things we need to go over before we end this episode. A few more things pertaining to Miss Stephanie Cooper. The first one is her reviews. That's right, her reviews. So you can actually go on the internet, beautiful thing we have these days, and you can type in an attorney's name and you can read reviews that people have left. Let's go ahead and read a few reviews, and by the way, you're all welcome to do this. You'll return the same result I did. This is not cherry picking. This was not digging for bad information. These are the reviews that showed up first when I typed in Stephanie's name. January 28th, 2016. I am very unsatisfied with Stephanie Cooper's performance of handling my divorce case. She repeatedly told me it would be done in 2 weeks. It ended up taking 2 weeks under 2 years. She whittled away at my deposit money until it was gone. There's more you can read on each of these reviews, but I'm just going to read a small portion of each of them. Again, you can go to Google, type in her name. You can read these full reviews yourself. Can't be trusted to do what she says a person on July 2nd, 2015. I hired her for a nonviolent criminal defense. The plea deal was not the same when I arrived at court, and she didn't properly explain why the plea deal was changed at the last moment by the district attorney. She told me before court that I would be in jail for 90 days, and then it was changed to 6 months. Not worth the money, says one man on July 8th, 2014. Miss Cooper represented me in a family law matter. She conducted the entire case behind closed doors. Several times she told me we were going to court. However, after paying her for months to prepare the case, each time the lawyers and judge disappeared behind closed doors, only to emerge in 20 minutes with me being told what I was to do. Definitely don't recommend on January 9th, 2011. Stephanie was nearly impossible to get in touch with. She never returned phone calls, rarely returned emails, and was never in her office. When I did manage to have an appointment with her, I had to wait an inordinately long time in the lobby. My last appointment with her was her first of the morning at 9 a.m., and she was 45 minutes late. She's a ripoff. December 16th, 2008. Stephanie takes your money but never completes the case. She has nobody to answer her phone. She is never in her office, and she never returns calls. For the ones that she was supposed to be representing who are in jail, they can never get in touch with her. She never follows up with anything or anybody. How in the world can she call herself a lawyer? Other people who have paid her money's words, not mine. These are the dissatisfied customers of Stephanie Cooper, which unfortunately was the attorney that John chose. In hindsight, clearly a mistake, but still needing to be held accountable. Last thing I want to talk about in terms of Miss Stephanie Cooper is a very interesting article I uncovered from January 26th, 2011. I'm going to go ahead and read it here. Stephanie Cooper joins the race for Center County Judge. Bellefonte-based attorney Stephanie L. Cooper formally announced Wednesday afternoon her plans to run for a common pleas judge seat in Center County. A registered Democrat, Cooper plans to cross-file to appear on both major parties' ballots for the primary elections this year, according to a press release. She is the third Center Countian to indicate plans to run for a Court of Common Pleas judge seat in 2011. Then the article goes on to talk a little more about her background, her qualifications, and exactly why she should be the judge in Center County. Now, she did not win this seat, as evidenced by the fact that she was representing John as an attorney still, but there's something very important that I've learned after just requesting some information from legal sources as well as attorneys that I know. If you want to be a judge, you have to play the game. Now, I'm not insinuating that every level of government is corrupt. I'm not insinuating that our court systems are completely corrupt. What I am insinuating, though, is judge seats are very hard to obtain. And they also tend to be seats that, unless you do something to really screw up your job, you will hold until you either retire or die. So this is a very comfortable and very highly regarded position to aspire to. Not many attorneys, in comparison to how many attorneys there actually are and how many judge seats are open, actually actually get to become a judge. So just connecting the dots here, it is fair to say that an attorney aspiring to become a judge in an adjacent county would likely be looking to find favor in the eyes of other judges who would then endorse or at the very least support her in her campaign. Now, if I were to guess what that might look like being played out in practical terms, it would look a lot like not resisting a judge if that judge was simply trying to get business done or had an agenda where they wanted to see through, and the attorney, though being paid by the defendant, was willing to bend the rules a little bit or at least make it so the client complied with what the judge was hoping to have done, process the legal system quickly. There's no definitive proof in that statement, and I want to make it clear for the record that I am not insinuating corruption on Judge Cherry's part and Stephanie Cooper's part in unison with one another. I am simply noting that this is a commonly held belief amongst legal professionals, and there is certainly the opportunity for conflict of interest to arise in a situation like this. The last couple of things I want to talk about before we move on to the next episode is public defenders. You see, public defenders are supposed to be the last line of defense, literally, for a citizen with no options left and staring down allegations in court. It's a good system to have in place to make sure that those who don't have the money or the means to represent themselves in court or to hire an attorney have access to representation. It's a fantastic program. I'm glad they have it. The only problem is you actually have to qualify for a public defender first. Now, John, few months prior, actually was, I believe, about a year prior, you can go ahead and check out the document CC17 within the Dropbox file to figure it out for yourself. He had requested spousal support at a domestic relations hearing, asking that since Tara had access to all of their money, if you remember back to the first episode, I talked about how one of the issues with PFA violations is it cuts the accused off from any access to their financial records or their financial institutions. If the one who is lobbying the accusations wants to solely possess those, they can. It's one of the downsides. It's one of the reasons that a PFA is an unconstitutional law. So, John had requested spousal support. John was denied spousal support. Basically meant he had no money other than his Social Security check that was coming in each month. Yet he was still, on April 6, 2016, denied for a public defender. The reason? Over-income guidelines currently in effect. I talked to John about this. He said they wouldn't tell him exactly why he made too much money or exactly how he made too much money. They only told him that he made approximately, and get this is not hyperbole, he made approximately $20 too much per month to be eligible for a public defender. Not $200, not $2,000, approximately $20 per month too much to be eligible for a public defender. So let's take a step back before we close out this episode and examine everything from a bird's eye view. John has been asking his attorney for months to file certain paperwork to advocate for him, as he is supposed to do. He's paid $2,175, and per emails that he maintained copies of, they had agreed to a payment arrangement. He was actually ahead on that arrangement for a while and stopped paying her when she would no longer contact him or submit any paperwork to the courts on his behalf. Then, at jury selection, when John believes he's going to talk to her and finally clear some of this up, she files a motion to withdraw his counsel. She is very misleading to Judge Cherry at this time, and John, feeling railroaded, and I mean, let's face it, a 78-year-old man, emotional and, just experiencing essentially hell on earth at the expense of the legal system, he doesn't exactly know what to do at this point. He showed up at this jury selection hearing thinking that he was going to have a lawyer advocating on his behalf, and instead the lawyer's advocating as to why she should no longer be his attorney. So, Stephanie Cooper is no longer his attorney, and all of this happens. Judge Cherry grants the request for Stephanie Cooper to withdraw his counsel, with them knowing and having public knowledge of the fact that John had been denied for a public defender already. So if you remember back to when I read this transcript and Judge Cherry said that John now had time to seek out counsel before he actually had his jury trial, that was a load of BS. Because they knew he already couldn't afford an attorney. He'd already paid money to Stephanie Cooper and she had done nothing. He didn't have any access to the spousal income between him and Tara, who were now estranged. And he had been denied a public defender on the basis that he made $20 too much per month. Boxed in, no options. You tell me, what exactly was he supposed to do at that point? Thanks for listening to this episode of Corrupt Clearfield. Remember, you can follow along with all of the documents I'm referencing at corruptclearfield.com. Just scroll down and click the link to the Dropbox file. All the documents are cataloged in order as they appear in each episode. You can also help to support this investigation as it continues, and also our family as we attempt to recover from the damage that has been done. You can donate either by going to corruptclearfield.com and clicking the link as you scroll down the page, or you can go directly to paypal.me/crazygaby. That's my broadcasting alias. Again, that's paypal.me/crazygaby. A, Z as in zebra, Y, G, A, B as in Bravo, E, Y. Thanks for listening. Until next episode.